Hello, everyone, and thank you for joining me for the July 2018 Michigan PIP Monthly, a complimentary Secrest Wardle broadcast that provides you with updates and case law from the Court of Appeals and the Supreme Court, and also discusses a hot topic in litigation or a trending topic that seems to be on everybody's minds this past month. My name is Javon David. I'm a partner at Secrest Wardle's Troy location. So let's get started. So today we've got a few cases to talk about from the Court of Appeals. One is actually a published decision, which is binding on all trial courts in making rulings. The other two are unpublished decisions, which have persuasive authority. And of course, in our trending topics in no-fault litigation for this month, we'll be discussing the Bazzi versus Sentinel decision that is a long-awaited Supreme Court decision regarding the innocent third-party rule and its impact on no-fault claims. My partners, Mark Masters and Renee Townsend, presented a complimentary webinar series specifically devoted to discussing Bazzi versus Sentinel and the impact therein. You can find that on our website or download it on Apple iTunes. Now, the first case out of the Court of Appeals is Woodring versus Phoenix Insurance Company, which was issued June 28, 2018. In that case, the plaintiff took her vehicle to a self-service car wash in early February. She parked her vehicle in the designated wash area but left it running. She began washing her vehicle, and as she worked her way around the rear of the vehicle, she slipped and fell and sustained injuries. Plaintiff testified that she did not know what she slipped on, but she believed that she may have fallen on ice. It was undisputed, nevertheless, that plaintiff was not entering, occupying, exiting, or touching the vehicle at the time of her fall. Now, following her fall, the plaintiff sought first-party benefits from Phoenix Insurance Company, and the carrier denied the first-party benefits on the basis that her claim was barred by the parked vehicle exclusion under the Michigan No Fault Act, which is found at MCL 500.3106. After her claims were denied, the plaintiff filed suit against defendant. She contended that she was injured while performing maintenance to her vehicle, so her claim was not affected by the parked vehicle exception. Instead, her claim was governed by MCL 500.3105. At the trial court level, the defendant moved for summary disposition, and plaintiff responded with a counter motion for summary disposition, having the court find that her claim was governed by 3105 instead of 3106. The trial court denied defendant's motion for summary and granted summary disposition in favor of the plaintiff. The granting of summary disposition was based in significant part on the fact that precedent from the Michigan Supreme Court was, quote, confusing and had not clearly overruled precedent, unquote, from the Court of Appeals. So therefore, the precedent that the court relied on in this case remained good law. So much of the very lengthy opinion went through whether certain cases, such as the Mussel versus Golchev case, I can provide you that citation if you need it, remained precedential. In Mussel, the court held that washing a car does constitute maintenance that precludes the parked vehicle exclusion. In assessing Mussel, the court indicated that just as Michigan residents are completely expected to have some awareness of the practical implications of snow and ice, any Michigan resident would be aware that keeping their cars clean keeps them running longer and without danger. Given the condition of Michigan roads and the salt used for snow and ice, cleaning a car is essential to being able to see while driving. So there are many cases that were analyzed by the court in this Court of Appeals opinion, but ultimately the court said that these cases that they analyzed do not overrule Mussel. Instead, the Court of Appeals indicated that it should be clear that a vehicle is not necessarily parked just because it is stopped, halted, standing, or otherwise not presently in motion. Indeed, the Michigan Supreme Court has indicated in the past that lack of vehicle movement merely triggers a requirement to consider whether the vehicle is therefore parked. So in other words, if you're looking at a claim, just because a vehicle is parked doesn't necessarily mean that someone is disqualified from benefits. What has to happen at that point is that you're required to consider whether the vehicle is considered a parked vehicle under the No Fault Act and whether that person is entitled to first-party benefits depending on the facts. So at the pre-suit level, you're really going to want to ask a lot of questions about what the claimant was doing at the time that the vehicle was parked or stopped or halted in some way. So for example, if you were the adjuster on this case and the claimant calls in and said, "Oh, I was washing my car and I sustained injuries," you want to know, what exactly was she washing? Was she cleaning the tires, cleaning the mirror, clearing the windshield? You want to know, was she touching the vehicle at the time of the fall? Was there anything around the car that made the claimant fall? So you don't want to just say, okay, well, it's a parked vehicle, therefore there's a parked vehicle exclusion, because that's truly just not going to be enough. And you don't want to be held to an unreasonable denial because you didn't ask the right questions when you took in that first intake call or you were working with the claimant to gather the bills and all of those things. So this Court of Appeals case is a perfect example of gathering all of the information because they truly looked to exactly what the plaintiff was doing at the time that she had fallen. And they looked to see whether that would constitute a parked vehicle. So ultimately, the Court of Appeals found that the maintenance exception applies to the facts of that case and that there was a sufficient nexus between the plaintiff's injuries and the maintenance of the motor vehicle as a motor vehicle. Therefore, the Court of Appeals affirmed summary disposition in favor of the plaintiff. Now, interestingly, and you don't see this a lot in the opinions, but Judge Riordan of the Court of Appeals issued a very strong, concise dissenting opinion. He believed that summary disposition plainly should have been granted in defendant's favor because there was no question of material fact that the connection between plaintiff's injuries and her automobile was incidental. He noted that plaintiff slipped and fell due to a condition on the land. The floor of the car wash was slippery or icy. She testified to those facts. The mere fact that she may have been washing her vehicle at the same time was, according to the judge, without question, incidental, fortuitous, or but for. And he relies on the case that we often cite is Thornton versus Allstate, which is a strong case for the defense about the incidental nature of these kinds of injuries. So this dissent kind of tells me that there will likely be an additional appeal to the Michigan Supreme Court on this Woodring case, but we'll just have to see if the parties do pursue that avenue down the line. So ultimately, in the Woodring case, the plaintiff was entitled to PIP benefits under 3105 as she was performing maintenance on her vehicle by spraying the windshield at the time of the fall. Now, the next case out of the Court of Appeals is the Klein versus Allstate case, which is an unpublished decision. Therefore, it is not binding on the trial courts, but still can be used as persuasive authority and can also be used to examine what happened so that when you're adjusting your cases pre-suit, you understand what it means to be an owner of a vehicle. So in Clayton versus Allstate Insurance Company, the Michigan Court of Appeals reiterated the proper focus for determining whether a person is an owner of a motor vehicle for purposes of the Michigan No-Fault Act. The focus is properly on the nature of the person's right to use the vehicle for over 30 days and not whether they actually used the vehicle during that time. Now, in this case, while the plaintiff's testimony created a question of fact as to whether he purchased the truck or ever drove the vehicle, plaintiff did not present any evidence to dispute whether he had the right to use the vehicle. So defendant filed a motion for summary disposition, arguing that as the owner of the involved uninsured truck, the plaintiff was not entitled to PIP benefits. Defendant asserted that the record established plaintiff purchased and regularly used the truck in question, but failed to get insurance on the vehicle. As we all know, if you fail to use a vehicle that's uninsured, you can be precluded from first-party benefits. In support of its motion for summary disposition, defendant relied upon the testimony from the seller and plaintiff's girlfriend. The seller testified that he sold the truck to plaintiff for $500. Plaintiff said he paid $300 up front and then $200 at a later date. The testimony of the plaintiff's girlfriend corroborated the testimony from the seller. Plaintiff testified that the truck actually belonged to his girlfriend. However, the girlfriend testified that plaintiff found the truck, negotiated the deal with the seller, gave the seller money, and then drove the truck home. So her testimony was clear that plaintiff acquired the truck for his own personal use instead of her own use. In addition, the plaintiff's girlfriend, probably not his girlfriend any longer, testified that plaintiff began using the truck right away, that he drove it every day to and from work, and that he drove her around in that truck. She also testified that plaintiff parked the truck at his mother's house and always kept the keys on him, meaning in his pocket or somewhere where he could easily access the keys to the vehicle. She even asked plaintiff for permission to use the truck because it was his. And lastly, according to the plaintiff's girlfriend, plaintiff planned on purchasing insurance and was going to register the vehicle when he had the money to do so. So basically, he bought this truck for $500. He didn't have the money to purchase the insurance, but he was still driving the truck around. All that testimony was obtained by the plaintiff's girlfriend. In response, plaintiff just across the board denied that he was even the owner of the truck. He really had nothing else except from his own testimony stating that he didn't own it and that he didn't necessarily purchase it and that it was his girlfriend's and all of that. So following the motion for summary disposition, the trial court found that plaintiff was a constructive owner of the uninsured truck involved in the accident and that the complaint against defendant should be dismissed. Plaintiff appealed the ruling, stating that the trial court erred by concluding that he was an owner of the uninsured truck. The Court of Appeals looked to the statutory definition of owner, which defines an owner of a motor vehicle as a person renting a motor vehicle or having use of a motor vehicle under lease or otherwise for a period that is greater than 30 days. And that's MCL 500.3101 for your records. I know you're all taking diligent notes here. So to qualify as an owner, a person does not need to actually have used the vehicle for more than 30 days before the accident. Nothing in the definition of owner requires that person to have actually used the vehicle at any time. Rather, the person must have had the right to use the vehicle for a time greater than 30 days. Now, ultimately, the Court of Appeals found defendant sufficiently established that plaintiff's conduct after the truck was acquired rose to the level of ownership. It didn't matter if plaintiff denied purchasing the truck. Instead, the proper focus was on the nature of his right to use the vehicle and not whether he actually used the vehicle. So while plaintiff's testimony created a fact question as to whether he purchased the truck and whether he drove the truck, the plaintiff did not present any evidence disputing that he had a right to use the truck after it was acquired. So under these circumstances, the plaintiff qualified as an owner, and the trial court properly determined that the plaintiff was the owner of the uninsured truck, thereby precluding him from entitlement to any first-party benefits. So essentially the rule in that case is that the proper focus for determining whether a person is an owner under the No Fault Act is not just to look at whether or not they purchased the truck, but did they have the right to use the truck for 30 days? So you can assess the nature of the right to use the vehicle and not whether they actually used the vehicle. Now, the next case from the Court of Appeals this month is Homeowners versus Great Northern Insurance Company. This is also an unpublished decision, but it really goes through priority under the No Fault Act and discusses what to look at when determining involvement of a motor vehicle for determining priority of payment of PIP benefits. So in Homeowners versus Great Northern Insurance Company, the Court of Appeals addressed the distinction between whether a claimant is in, on, or upon a vehicle for purposes of determining involvement of a motor vehicle and thereafter determining priority for payment of PIP benefits. In that case, Homeowners filed a lawsuit for recoupment of first-party benefits paid on behalf of Matthew Thiessen arising out of a motor vehicle accident that occurred in May 2016. At the time of the accident, Mr. Thiessen and his wife held a policy of insurance with Homeowners. Ms. Tyson was also insured at the time as an employee by Great Northern Insurance Company. On the date of the incident, Mr. Thiessen and Ms. Tyson were engaged in a verbal argument at home. Ms. Tyson exited the home and went to Mr. Thiessen's vehicle to remove the registration and proof of insurance from the car. She then entered her work van, which was parked on the road in front of their house. Mr. Thiessen followed her to her work van to retrieve the documents, and then they continued to argue around the car itself. Mr. Thiessen testified that the door on the work van was open, and he was able to get between the door and the driver's seat to reach over Ms. Tyson for the documents. Mr. Thiessen testified that the work van was moved by Ms. Tyson, causing him to be dragged by a vehicle. He could not recall whether he grabbed any part of the vehicle while he was being dragged. Ms. Tyson testified that she had put the work van in motion and was in the process of closing the door when Mr. Thiessen grabbed the door handle and her arm. He then grabbed her steering wheel while walking alongside the vehicle. The vehicle then took off and he was hanging by the vehicle for some time while driving. So it's essentially a domestic dispute gone wrong, where a claimant was injured by being dragged by a motor vehicle driven by his wife. And the issue here is which policy controls. Is it going to be the personal policy of the person injured, the main priority, or is it going to be the insurer of the work van? And all of this came down to the parties disputing the meaning of the word occupant under the No Fault Act. So Mr. Thiessen then files a lawsuit seeking payment of first-party benefits and a declaratory judgment as to priority between the two potential insurers, which was his own no-fault insurer under his personal policy or the insurer of his wife's work van. Mr. Thiessen alleged that because he was an occupant of the work van, Great Northern was highest in priority under 3114. Thereafter, Mr. Thiessen filed a dispositive motion on the issue, and in doing so relied on the dictionary definition of upon, where he argued that upon meant on, and that on evidences physical contact with another object. So basically he's saying that I was upon the vehicle and I had physical contact with the other vehicle. So Great Northern responded and argued Homeowners was highest in priority because Mr. Thiessen's argument regarding 3114 priority language expanded the definition of occupant to equate occupying a vehicle with merely touching a vehicle. The trial court ruled in favor of Mr. Thiessen and determined that Great Northern was highest in the order of priority under 3114 on the basis that Mr. Thiessen was hanging on to the work van. Therefore, he met the definition of upon. So there was more than mere contact with the work van, thereby making him entitled to first-party benefits through Great Northern. So the key issue on appeal was whether Mr. Thiessen was considered an occupant of the work van for purposes of the No Fault Act. And in dissecting this issue, the Court of Appeal specifically addressed the language of 3114 subsection 3 and the definition of an occupant under the statute, which is not specifically defined in the No Fault Act. And as we all know from law school and just practicing claims all the time, if something is not found in the No Fault Act, then you go to the dictionary definition. So the Court of Appeals examined the relevant case law and ultimately determined that the definition of occupant requires the claimant to be physically inside the vehicle. The Court of Appeals reasoned that it was doubtful that the primary and generally understood meaning of the word occupant would include merely being dragged alongside a vehicle or being moved by the vehicle while having some contact with it. Moreover, the Court of Appeals found that Michigan Supreme Court's past observations on the words on and upon had to be interpreted in the context of the word they are defining, which in this case was the term occupant. And finally, the Court of Appeals found that the trial court had improperly concluded that Mr. Thiessen was hanging on to something inside the vehicle and was voluntarily using the vehicle to transport himself when there was no evidence of Mr. Thiessen voluntarily using the vehicle for purpose of transportation, and there was conflicting accounts as to the specific facts surrounding how the accident took place. Thus, the Court of Appeals determined that the trial court erred as a matter of law and sent it back to the trial court. So the takeaway from this is that since occupant is not defined in the No Fault Act, the specific facts of each case will need to be examined to determine whether a claimant was an occupant of a motor vehicle at the time of the accident. And again, I'm sure as you're all trained in your claims handling, when you get that initial intake call about an accident, or if you're adjusting a claim at any point in litigation, you want to know the exact facts. What was happening at the time of the accident? Were you inside or outside of the vehicle? Were you touching the vehicle? Were you dragged by the vehicle? Ask as many questions as you can so that you have a true and complete understanding of exactly what was going on. Ultimately, the rule here is that in order to be an occupant of a vehicle, a claimant must be inside of the vehicle. And finally, the moment you've all been waiting for, a discussion on Bazzi versus Sentinel Insurance Company. I'm just going to go over an overview of what Bazzi held and just kind of the impact that it can have pretty quickly. Here, my partners Mark Masters and Renee Townsend have an entire webinar discussing the Bazzi case. And in fact, Secrest Wardle had the Bazzi case, and we were the trial attorneys on that file. And Mark and Renee do a good job as going through the procedural history. Mark handled the trial court case, so he talks about his perspective. And then they do a nice, thorough analysis of what this means for all of us going forward at the claims level or even in litigation. Now, in Bazzi, plaintiff Ali Bazzi sought first-party benefits for injuries he sustained in an automobile accident while driving a vehicle owned by third-party defendant Hala Bazzi, who was his mother. The vehicle was driven by Ali was insured under a commercial automobile policy issued by Sentinel to Mimo Investments. Sentinel asserted that the policy was fraudulently procured by Hala and third-party defendant Miriam Bazzi, who was the plaintiff's aunt and also the resident agent for Mimo Investments, in order to obtain a lower premium because of Ali's involvement in a prior accident. So basically, Sentinel believed that Ali's involvement in a prior accident would have raised their premium, so they did not disclose him, and also they procured the commercial policy to get a lesser premium. In support of this contention, Sentinel offered evidence that the vehicle was actually leased to Hala for personal and family use and not for commercial use by Mimo company that she had, and in fact that Mimo was essentially a shell company that had no assets and no employees and was not otherwise engaged in business activity. Sentinel also alleged fraud in that Hala and Miriam failed to disclose that Ali would be a regular driver of the vehicle involved in the accident. Now, so Sentinel pursued a third-party complaint against Hala and Miriam Bazzi, seeking to rescind the policy on the basis of fraud in the application. That action resulted in a default judgment against the Bazzi sisters. Sentinel then moved for summary disposition of Ali's first-party suit because the policy was rescinded on the basis of fraud and was therefore void ab initio. The trial court denied the motion, concluding that Ali had a claim because of the innocent third-party rule. Sentinel then moved for interlocutory review from the Court of Appeals, which denied leave. However, when Sentinel, through Secrest Wardle's appellate department, applied for leave to appeal to the Supreme Court, the court, in lieu of granting leave to appeal, remanded to the Court of Appeals for consideration as on leave granted. So on remand, the Court of Appeals held in Sentinel's favor. When the Supreme Court finally addressed the question on the merits earlier last week, the 5-justice majority held in an opinion by Justice Wilder that the Court of Appeals was partially correct. So the court said, insurers may seek rescission of an automobile insurance policy on the basis of fraud in the procurement of the policy, since nothing in the No-Fault Act forbids this. However, the Court of Appeals majority erred by treating the rescission as the automatic end of any third-party claims. So while the Supreme Court acknowledged that rescinding a policy void ab initio and is considered to never have existed is something that would seemingly mean no one could claim benefits under it, the court emphasized that rescission is an equitable remedy and therefore equitable considerations must guide whether a particular party's claim is terminated. So, in other words, before the claim of an innocent third party can be dismissed, trial courts must balance the equities to determine whether the insurer is entitled to the relief that he seeks. So, what exactly this means will, without question, be the subject of future motions and leave applications, where we're going to be fighting in court as to how the scales of equity tip in one favor or the other. Is it going to tip in favor of this person or the insurance company? Now, the Bazzi majority did offer some insight as to how we can resolve this. So they say that where one of two innocent parties must suffer by the wrongful act of another, meaning this third party, or the party that committed the fraud, that one must suffer the loss through whose act or neglect such third party was enabled to commit the wrong. The doctrine is an equitable one and extends no further than is necessary to protect the innocent party in whose favor it is invoked. So, in the case of Bazzi, rescission did not function by automatic operation of law. Just as the intervening interest of an innocent third party does not altogether bar rescission as an equitable remedy, neither does fraud in the application for insurance provide an insurer with an absolute right to rescission with respect to third parties. We expect that plaintiffs will no doubt argue that insurers collect a premium and are in the best position to identify fraud in the application phase, so the equities weigh in favor of insurers bearing the burden of fraudulently obtained policies. However, it is unclear how this does not simply repackage the easily ascertainable fraud rule that Titan expressly rejected. Much would also seem to depend on whether truly innocent claimants still have time once a policy is rescinded to seek redress from the assigned claims facility. From the defense perspective, I would say that your motion for summary disposition based on this issue would be more likely to be granted if the person still has the ability to go to the assigned claims plan. So you're not leaving them without any kind of recourse. So ultimately, the Bazzi court is directing lower courts to consider rescission and innocent third-party arguments on a case-by-case basis. So they have to look to the entirety of the fraud. They have to look to whether or not the fraud was easily discoverable by the insurance carrier and what position that would leave someone in if the motion were to be granted and the policy were to be void ab initio, precluding even innocent third parties from recovering first-party benefits. So in other words, a trial court presented with the rescission defense is required in the exercise of its equitable powers to determine which blameless party should assume the loss. And that's going to be something that the trial court judges are going to have to decide on a case-by-case basis. Now, like I said earlier, my partners Mark Masters and Renee Townsend prepared a very thorough, in-depth analysis of Bazzi versus Sentinel, and you can find their podcast on Secrest Wardle's podcast homepage, Apple Podcasts, and Google Play. The full webinar is available at secrestwardle.com, but I'm going to play for you just a summary of their findings to give you their perspective and their overview.
Basically, the bottom line is that an insurance policy procured by fraud can be declared void ab initio by an insurance company, but that rescission of that policy is not a right as to an innocent third party, but an equitable remedy granted in the discretion of the court. The trial court must then balance the equities to determine if rescission is a just and equitable remedy in each case, and basically decide which party should assume the loss when both parties are equally innocent.
Thank you for attending Michigan PIP Monthly for July of 2018. Again, my name is Javon David. You can contact me at the information listed on the slide that has my email and phone number there. We'll see you next month, and thanks for tuning in.